California residents, as well as people across the nation, are aware of the much publicized and contentious lawsuit surrounding Proposition 8, the California ballot initiative passed by the voters in November of 2008 that amended the California Constitution by defining marriage. Not long after the initiative was passed, the law was challenged in court. In August of 2010, a federal judge held that Proposition 8 violated the Equal Protection Clause of the 14th Amendment to the United States Constitution. That decision has now been appealed to the Court of Appeals for the Ninth Circuit by the proponents of Proposition 8. Before the case can be argued on its merits, however, one threshold issue must be resolved: whether the citizen proponents of Proposition 8 will be allowed to defend the law in court. The Ninth Circuit has now asked the California Supreme Court whether a ballot initiative's proponents have standing to appeal. Under procedural rules, a party to a lawsuit must have standing. In layman's terms, this means that a party must have a sufficient interest in the outcome of the litigation to justify his participating in the suit. He cannot merely be a bystander with a passing or marginal interest. While this sounds like a technical and uninteresting issue, it is an issue that is of vital interest to the voters of California. You see, in this case, the Attorney General of California and the Governor of California, both past and present, have refused to defend the will of the voters. Since the state is refusing to defend the law, there is no one to advocate for the voters of California in court unless the proponents of this ballot initiative are allowed to have their day in court. As a result, this is not just a case about Proposition 8, this is about all California ballot propositions. This is not the first time elected officials of the state have refused to defend a law supported and passed by California's voters through the initiative process. In fact, the initiative process, which traditionally has been strongly defended by California's courts, exists precisely to allow the people to have direct legislative authority when their elected officials are unresponsive or antagonistic to voter interests. For this reason, Pacific Legal Foundation is filing a Friend of the Court brief with the California Supreme Court, urging the court to hold that ballot proponents must be held to have standing in cases such as this. Any other finding would be tantamount to nullifying California's initiative process, and more critically, nullifying California's voters. It would give California's governor and attorney general the power to veto any ballot initiative that he or she did not like. So PLF's amicus letter filed in the California Supreme Court has been filed on behalf of several other folks and entities who have a lot of experience with supporting and defending ballot propositions in California. Among them, Ward Connerly, famously associated with Proposition 209, Ron Unz, associated with Proposition 227, and the Howard Jarvis Taxpayers Association, which is certainly well known in this state for Prop 13 as well as other property-related measures. PLF is hopeful that the California Supreme Court will indeed accept the certified question from the Ninth Circuit and answer in the affirmative that those who support and have sponsored ballot measures in this state do have the right to defend their ballot measures in court.